Thank you, dear colleague. Thank you also for the invite and the opportunity to present in this colloquium. It's really an honor and a privilege to be here amongst well-vested practitioners and academics. It's really a great opportunity to be here to broaden one's horizons. As Scholar has mentioned, I'm Lerato. I'm a lecturer at the University of KwaZulu-Natal. I'm fairly new into being an academic, so I'm an emerging scholar, if I can put it like that. Without any waste of time, I would like us to move into my presentation. I'll be speaking about or presenting on meaningful engagement or mediation in disputes from or out of the extension of Security of Tenure Act. This paper, it forms part of an article that I'm writing, and it's currently under review. So by way of an introduction that is setting the scene, disputes, in my focus particularly is in terms of how disputes they arise and I propose they should be solved under the extension of Security of Tenure Act. So, I've been in academia and also being associated with particularly the Stellenbosch Law Clinic, where they receive more of matters related to Esther, that is Esther occupiers having some issues with the private landowner in the farm that they're either working or they're a labor tenant or anything, they're staying in that particular farm. So there are a lot of disputes. Some of them, they relate to relocations or evictions. So we see that Esther provides a mechanism to solve these particular disputes. This mechanism is evident in the provisions that entitles an owner to apply to court for the relocation of that particular occupier or the eviction of that particular occupier. So you find that the particular landowner, when they apply to court, they don't really exhaust, if I can say, preliminary remedies, and they just shoot straight to approach the court and so on and so forth. And also, when we look at the mechanism of Esther, particularly Section 21, it requires disputes that arise from within Esther to be solved or facilitated via mediation. And when we look at things, how things are going or how it is being done in practice, particularly learning from my drawing lessons, from my practical experience working with the law clinic as a consultant, usually this part of the act, it's not really being relied on, it's not being used, it is just there, and nothing is being done about it. But one other thing which seems to not be, this part not being active, we don't have a formal way or a formal structure of mediators involved, particularly in Esther. So it's just quiet relating to this mechanism. So whenever issues arise between a landowner and an occupier, you find that they go straight to the court. They were not even engaged in mediation or meaningful engagement to such effect. So, I like how Nupen defines mediation. It says mediation is the process in which parties in a conflict, they voluntarily enlist the services of an acceptable third party to assist them in reaching an agreement on issues that divide them. So we always see, I've always seen this division between Esther occupiers and landowners, whereby there's no understanding, it's people, they don't want to talk about the issues at hand. They just straight want to go to court. Even the occupiers themselves, when they either want to improve the dwelling that they are staying in, or they want to do something extended, they don't want to talk to the landowner. They just want they don't want to engage at all. And if he refuses, they just want to go to court. They want to take them to court, and then sometimes they will come to the law clinic and they will seek advice and stuff. So in this paper, I'm trying to question whether I'm proposing try to question whether we should follow meaningful engagement, we should do mediations in terms of resolving disputes that arise from Esther. When we look at meaningful engagements and its origins, it's a process. It was the origins of meaningful engagements that are set out in the Oliver Road, Bereatown case, where meaningful engagement was stated as a process in which two or more parties, they talk and listen to each other meaningfully in order to achieve certain objectives. In this regard, meaningful engagement is used as a deliberative tool to resolve disputes and to increase the understanding and sympathetic care of the parties affected in that particular instance or in that particular circumstances. So I've been taking stock, particularly cases relating to Esther, that is the extension of Security of Tenure Act. We have Daniels in that an occupier wanted to make improvements. The occupier did not properly engage with the landowner, and then the landowner refused, and then the occupier went on with the improvement, and then the landowner tried to stop, and then the matter went to court, and then the constitutional court ordered them to meaningfully engage. In Erasmus vs. Mutanje, an occupier's building was demolished by the landowner, and then the landowner was sleeping in tents, which the tent was not habitable. And then now the occupier erected an informal structure, which the landowner was not happy because it did not conform with the title deed. In the landowner argued that it was not in line with the title deed that was allocated to that particular space and stuff. So there was an issue of whether there should have been talks between the two. And then also in Tanje, the court ordered parties to meaningfully engage. So there is this one of Orange, whereby a farm manager wanted to be, they relocated the farm manager from the manager's quarters to ordinary quarters, and then he refused to move. But when it went to court, the court allowed gave the landowner the power to relocate the particular manager to the ordinary quarters. And then there were some issues in terms of also of engagement there. And also in Mujoli, these particular ones, they were staying in a particular side of the farm, and then the landowner wanted to move them to another side where it was more habitable. They could have sanitation, access to water and stuff. Where they were living, the buildings were no longer fit for human habitation. And then the occupiers refused to be relocated. It was a farm in the same site. They refused to move. And then the court ordered them to move because the magistrate said the other side was habitable for them to live in, and the other side was not fit for them to move in. In terms of also engagement, things did not go well. And then there is Diagar versus Mazibuko. In Mazibuko, the occupier's family started to grow, and then the occupier decided to extend the particular dwelling without consultations or engaging with the landowner. So issues arose, and then they could not be resolved. And then the matter went to court, and then the court found that the occupier was not supposed to extend the matter without engaging with the landowner first, without talking with the landowner. They made reference to the case of Daniels. So the bigger question of this paper is I'm trying to compare between mediation and meaningful engagement, to see the appropriate approach to resolving disputes under Esther. So whether it's meaningful engagement or mediation, the use of meaningful engagement in these cases, I think my view is that it might be flawed for obvious reasons. It will will it make any sense between private parties? Because when we look at the origins of meaningful engagement and looking at Oliver Road case, you know, there the state was compelled to abide by its duties and to listen to the beneficiaries' needs. But in this particular case, you know, practically speaking, once private parties approach a court to settle a dispute, can we not assume that they have not been able to reach an agreement amongst themselves? And the question is where and how meaningful engagement will assist. So the assumption is that when they're already in court, you know, they were unable to solve the problem at hand. So why are courts, or the courts that are busy hammering on meaningful engagement, that meaningful engagement, that meaningful engagement, that? So meaningful engagement should be reconsidered with reference to case law where this remedy has been used and imposed. You know, I think courts should be more open to compulsory mediation, because we have seen mediation being a success in family law. You know, a lot of speakers, they've spoken to that, and also we have seen it between employer and employee. In that context, it has been a success. And Esther particularly, it requires that disputes be solved by mediation in terms of section 21, or even arbitration in terms of section 22. That's the suggestion of the proposal that I'm making through this paper. And also having authority from the Port Elizabeth municipality, where the former Constitutional Court Judge Usek says, you know, meaningful face-to-face meaningful engagement is particularly in context whereby the parties, they will still be living together, closely together. So it will help them to build relationships and enable them to be more proactive, enable them to be able to solve their disputes through a courteous way, through talking, through ironing out issues. So when looking at how meaningful engagement, you know, from my drawing lessons from the cases that I've been involved through the Stellenbosch Law Clinic, most of the time, you know, the courts will say go and meaningfully engage, particularly on evictions, and then we will submit the personal circumstances of the occupiers, and still you find that the farm owner or the state is not really happy with that, and then the meaningful engagement continues. So I think mediation from the outset should be more of a thing that it's adopted, particularly since we see that the landowner and the occupier, they will still have a long road to live together in the same farm. So it will enable to solve even future disputes, because mediation that's designed at the heart of it, it's resolving disputes, particularly looking at mending relationships that will last for a longer time, and for future resolving of disputes. So my proposal is that we move more into mediation rather than meaningful engagement, because meaningful engagement in these circumstances, it seems like it's not working, because you find that the parties after that they're unable to reach an agreement. And then perhaps if we move into mediation, I think it will ease up things, and disputes will be solved. It will be solved quickly and without any cost and without wasting any time, particularly when it comes to relocations of occupiers and mostly on evictions. I think that the reason evictions cases are taking a lot is because the courts, they order these parties to meaningfully engage. I think now courts should move towards meaningful engagement. I mean, mediation. Mediation will, I think it will assist us to iron out issues. So I don't have much to say for this moment. Thank you for your attention, and also let me thank the organizers of this conference and for affording me the time and the opportunity to partake and present in this conference. Thank you so much for your attention. I would invite questions and suggestions.
Lorato, thank you very much for your presentation, and specifically for our students who are present. You can see that mediation is also. I mean, the Lorato's presentation was based in property law, and you know, mediation can also be used. It's just an example in property law. Just one
Yes.
observation, Lorato, with respect to your quotation from Pretorius on your fourth slide.
Yes.
The Pretorius textbook is really outdated.
Yes.
It's out of print. It has been, the publication was a 1993 publication, which is, I think the last edition was a 93 edition.
Yes.
I still remember it's a red textbook. When he talks about mediation is a process in which parties in conflict voluntarily enlist the services of an acceptable third party. I think with the developments that have come through, they've added one more word there, and it's an independent third party, which replaces the word acceptable. So I just thought I'd add some value there. No criticism at all.
Yes, thank you. Because thank you so much. Because this was since we are working from home, it's a book that I was given to it by this professor who was just giving out books. So I picked it up, and then I was just interested on bringing in mediation into property law or property related disputes. Yes. And then when I found it, I just quickly used it. Thank you so much. But on the paper, I've referred to recent dissertations, particularly in articles on mediation.
No, 100%. I appreciate that. Also, you know, with regards, you talk about textbooks and that, you know, there are some more recent textbooks available. But you know, there's a lot of work that also needs to be done in terms of you know, publishing and you know, developing better, or I won't say better, but more textbooks with, for example, you take Rule 41A that has been introduced in the High Court. You know, there's an opportunity for colleagues present here, you know, write a textbook. You know, a lot needs to be written on Rule 41. There's a lot of criticisms on Rule 41A also. And I think there's going to be some interesting challenges in that regard. But that's just my comments. I see Johan has raised his hand. Johan, you have the floor.
Thank you. Yeah, that was quite interesting with saying everything except let's mediate. Yeah, perhaps what I just want to mention is, and we see that very often in commercial matters as well. There's not a lot of foresight in the drafting of the contracts. The building industry is a prime example thereof. That when they deal with the clauses in respect of conflict resolution, the default one is arbitration. And in a building industry, especially smaller contracts, the amounts that are in dispute or the work that are in dispute often doesn't justify arbitration. Arbitration is basically, it's a quicker process than litigation, but it's not really cheaper. And it's still a very complicated process that requires a lot of drafting of papers, etc., etc. And as perhaps just, and rather what I just want to contribute was that the mindfulness of practitioners in drafting the clauses in contracts that deals with conflict resolution needs to be sensible to refer to the correct things. For example, mediation, instead of all kinds of other things, and arbitration is seldom the answer, especially if it concerns the average man on the street that don't have money to litigate. So to provide him with another alternative dispute resolution process that's going to cost him a similar kind of money is also not practical. There's a lot more space for mediation to be considered before arbitration. Thank you. That's my 2 cents worth.
Thank you so much, Johan. Thank you so much.
Colleague, if I can just add to what Johan just mentioned now. One of the challenges with arbitration, in my opinion, is the outcome is final and binding. There's been a lot of development in recently, and I think I shouldn't be saying thanks to COVID, but with respect to arbitration, the recent developments with arbitration has actually added more opportunity for companies now to arbitrate virtually, if you wanna call that also. And I think there's been lots of opportunity for practitioners or mediation practitioners to conduct mediations virtually. So yeah, it's interesting times. Anyway, any other comments, colleagues? Any questions, Jan?
Thank you. Yeah, that is actually very interesting. My practice and also the training of things that we do are now mostly online. I very seldom mediate face-to-face. And in children's court matters, I also don't like to receive a report in respect of child participation from a social worker or psychologist. I prefer a meeting for various reasons that we don't have to get into now, with the expert as well as the parents, and you resolve issues somewhere there and then. Because you have the expert in the room that can facilitate that process that the opinion in writing just don't give you. But it's actually, and it's very interesting, if you speak to people like Nedru, she's got a different view that says that she sees that she missed more things, or that Zoom isn't as practical. And I think from other cases I had, our legal eagles will say, no, there's not much of a change in respect of what we see. Mental health professionals have a different view. It's very interesting that conversation. But I quite like the whole space to mediate in the cloud, and it works very well. And training also works very well. Thank you.
Excellent. Thank you very much, Jan, for your contribution, and Lorato.